Okay, hello everybody. Good afternoon. And on behalf of the Canadian Council of Muslim Women, we welcome you to CCMW's divorce webinar. We do have people trickling in, and I understand that 2 links were sent out, so that is completely okay. And we are going to get started with the housekeeping guidelines. So my name is Sabrine Azrak. I'm the National Projects Coordinator at CCMW, and I'm the moderator for the duration of this webinar. Before we begin, we just want to go through some housekeeping rules. So today's webinar is being recorded. The recording of this webinar will be available afterwards on our website at www.ccmw.com. We welcome you to revisit the content yourself and to share it with your networks. It will also be uploaded on CCMW's YouTube channel in due time. Please ensure that your video camera and your microphone are muted during the webinar and are turned off. This will help eliminate ambient noise and increase clarity. We invite your comments and your questions in a live Q&A session at the end of the webinar using the chat box. The chat box button is the 6th button from the left at the bottom of your screen. So once you click it, the chat box will appear on the right-hand side of your screen. If you think of a question at any point throughout the duration of the webinar, just type it into the chat box and I will during the Q&A portion. You could choose to ask the question anonymously by sending the message to the host, which is myself, or you can choose to send it publicly, whereas you would send it to everyone. An evaluation will be emailed to you later today. It will take about 5 minutes to complete. Please don't include your name on this form in order to maintain your privacy. The information you provide will be kept confidential and private. Only authorized individuals at CCMW will have access. And if you require any kind of technological assistance, please send me a direct message using the chat box, or you can send me a text message at 416-897-1907. And now for CCMW's vision and mission. So the Canadian Council of Muslim Women is a national nonprofit organization committed to attaining equality, equity, and empowerment for all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. For more than 37 years, CCMW has proudly advocated on behalf of Muslim women and their families and developed national projects that enrich the identity of Canadian Muslims, encourage civic engagement, and empower. In the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian Family Laws, a comparative primer in English and French, as well as a series of booklets in several languages on family law topics, public education efforts. Our latest project in this field, Muslim Women's Family, is updating these documents and disseminating them via knowledge sharing workshops within different cities across Canada, from Muslim women, community service providers, the legal profession, and the general public. In 2003, CCMW took the lead in establishing a coalition against religious arbitration, composed of over 50 sister organizations, including the National Association of Women in the Law, METRAC, and the YWCA. The No Religious Arbitration Movement and CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the province's Arbitration Act. CCMW was compelled to inform Muslim women about their choices and the choices they have available to them within Muslim and Canadian family laws, and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, as well as 15 local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. To learn more about CCMW, please visit us at www.ccmw.com. I am now going to turn it over to Pamela Cross, the facilitator for today's webinar.
Thanks, Sabrine, and good afternoon and welcome to all of you. We're very happy to have you with us today. This webinar is produced by the Canadian Council of Muslim Women. My name, as Sabrine has said, is Pamela Cross. I'm a lawyer, and I've worked with CCMW on a number of projects over the past several years. I work with a wide variety of women's rights and anti-violence organizations across Canada, and my focus of my work is always on violence against women and the law. I also want to welcome Prahat, who's joining us today, as he has for the last two webinars and will be for next week's webinar as well. He's the expert on Muslim family law. I am not, and so I'm hoping he will jump into the conversation anytime he wants to add to something that I'm saying, and certainly you can direct questions that are about Muslim family law to him, and he will be able to answer them for you. I'm honored to be facilitating this series of 7 webinars, which reflect the content in 6 brochures produced by CCMW that provide comparative information about Canadian and Muslim family law as they pertain to women's rights. The topics covered in those brochures are marriage, divorce, which is what we'll be talking about today, custody and child support, family property and spousal support, domestic contracts, and inheritance. Inheritance will be the subject of next week's webinar, which is also the final webinar in this series. The goal of the written materials, as well as these webinars, is to assist Canadian Muslim women in being able to make informed choices in the area of family law in Canada. We hope these resources will also be of assistance to professionals who work with Muslim women in the family court system, students who'd like to know more about these issues, and community-based services that assist women. And here you can see what the covers of all of those brochures look like. As Sabrine has said, they're all available on the CCMW website. The content of both the brochures and these webinars is based on Muslim and Canadian, a comparative primer, which you can see on your screen, that was published by CCMW in 2006. The materials were updated as of 2019 to reflect changes that have taken place in the law since 2006. Please note that the information contained in these webinars is just that. It's information. It is not legal advice, and it should not be interpreted or used as though it were. If you or someone you know is dealing with a family law issue, it's very important for them to meet with a lawyer to discuss their situation, to provide all of the details and facts about their family, and then to receive legal advice. In the area of family law in particular, legal advice is very specific to the facts of a family. The webinars, the brochures, and the primer are not a replacement for legal advice, although we certainly hope that you find the information in them helpful. If you want to find out about the sources and validity of Muslim laws and legal opinions referred to in the webinars, you should consult Muslim and Canadian Family Laws, a comparative primer. Laws in a public legal system are in a constant state of flux. They change to adapt to the times. And there's nothing that's a more current example of that than the Divorce Act, which we will be referring to a number of times in today's webinar. The Divorce Act underwent massive changes in 2019. Those have not come into effect yet. They become effective as of March 1st of 2021. So anybody who thought that they were coming into effect July 1st, you're not wrong. But a couple of weeks ago, the government announced that because of the pandemic, and because of the challenges that all of the court systems across the country are facing right now, implementation of the revised Divorce Act has been delayed until March 1st, 2021. But that law, as you will see it in March of next year, is very different from the law that's in place now and that's been in place for a long time. And that's what we mean when we say that laws in a public legal system like the Canadian legal system change to adapt to the times. What you hear today, what you read in the brochures, is accurate to the date the material was created. So in the case of the webinar, the information we're giving you today is accurate to today, June 30th, 2020. The material in the brochures is accurate to the date they were published, and that date, I believe, is printed into each brochure. If you rely on these materials in the future, we strongly encourage you to verify that it is still current at that time. At the end of my presentation, sorry, I've got a little slide problem here. At the end of my presentation, which will take probably about 30 minutes, as Sabrine has said, we will have questions and answers. Pose those questions by writing them into the chat area on your computer screen, and then Sabrine will read the questions out so everyone can hear them, and Omar and I will do our best to answer them. If there's a question we can't answer, or if we run out of time for questions, we will create FAQs that CCMW will post on its website. And I do encourage you to enter your questions as you think of them, because you might forget otherwise. Marriage in Islam is considered a contract, and therefore, like any contract, it can be dissolved. There's no strict equivalent to civil divorce in traditional Muslim doctrine, but there are a number of ways in which marriage can be terminated. The most obvious is through talaq, which is the right to unilateral repudiation, a right that is granted to the husband. Although classical Muslim law grants the man the right to end the marriage unilaterally without reason, such repudiation is considered reprehensible. And classical doctrine placed several procedural and financial hurdles to make sure it would be used as narrowly as possible. For a marriage conducted according to either Canadian or Muslim law, none of the Muslim methods of dissolution will be recognized by Canadian law as a valid divorce. In other words, if somebody wants a divorce that is recognized under Canadian law, possibly because they wish to remarry under Canadian law, they will have to go through a Canadian divorce, even if they also pursue a divorce under Muslim law. Under Canadian law, if two people are legally married to one another, either of them can apply for a divorce to end the marriage and resolve related issues such as custody, child support, spousal support, and property division. But they have to have been legally married under Canadian civil law. And we talked a lot about what makes a legal marriage under Canadian law in the first webinar. We've touched on it a couple of times in webinars since then. I don't want to be repetitive for those of you who've been with us throughout this whole series, but very briefly, for a marriage to be legal in Canada, it has to be performed by somebody who is licensed to perform marriages in the province where the marriage is taking place. And that person has to complete the required paperwork and file that with the government. If those things don't happen, if either of those things don't happen, there may not be a marriage that is legal under Canadian civil law. And if that's the case, the two people may not be able to get divorced because there will be no record that they were ever married. A woman in a polygamous relationship whose marriage is not registered, because Canada does not recognize polygamous marriages, and in fact, as we have talked about, polygamy is a criminal offense in Canada. A woman in that kind of situation would not be able to get a civil divorce in Canada because she's not considered to be married under civil law. As I said a couple of minutes ago, repudiation is the right given by Muslim law to the husband. He may repudiate his wife at any time without the need to give a reason. However, only men of sound mind who have reached the age of capacity may perform this. Repudiation by a minor or by someone who is mentally incapacitated is considered ineffective. Repudiation can happen without the wife being present, but she must be informed about it immediately. In general, no witness is required for the repudiation to be effective, although many scholars hold that this is in fact a condition. Most jurists also invalidate repudiation by an intoxicated man, since intoxication makes it doubtful that the words were uttered intentionally and as a result of a sound mind. Some, however, have believed that even when the man is intoxicated, the repudiation is valid. It must also be expressed by the husband in clear and unequivocal terms to be effective. In other words, it can't be vague. Given the seriousness of the matter, the language needs to clearly reflect the intention to end the marriage. Repudiation cannot happen when the wife is menstruating. The husband makes an unequivocal oral expression of his intention to end the marriage, after which the wife should remain in her husband's home for a waiting period consisting of 3 menstrual cycles. Even if the repudiation occurs during menstruation, most jurists would consider it valid, although not strictly proper, while a minority argue that the husband may be ordered to revoke such a repudiation. Even a proper and standard repudiation is revocable, in other words, can be taken back, in the sense that the married couple may simply resume their marital relations, and thus the marriage would resume. And as you'll see in a few minutes when we talk about Canadian divorce, there's a similar kind of clause about resume relations. However, only 3 revocable repudiations may be effected in one marriage. So if there's a repudiation and then the couple resumes their marital relations or the husband revokes, if that's happened 3 times, then dissolution of the marriage becomes final. It also becomes final if the waiting period elapses and the people have not resumed marital relations. Once that dissolution is final, the couple may not resume marital relations. If they do, it could be considered adultery. The marriage may not be resumed once again unless the former wife marries another man, consummates that marriage, and then separates from him. Marrying another man for the sole purpose of being allowed to return to the former husband is both illegal and considered to be reprehensible. Besides the standard form of repudiation mentioned above, many Sunni schools recognize the non-standard triple repudiation, whereby a husband repudiates his wife 3 times at once. Shia scholars largely dismiss the validity of such practice, and even within Sunni schools, it is discouraged. However, when this takes place, the marriage is instantly and irrevocably dissolved. A man may repudiate his wife in person or through proxy. This ability to grant someone the authority to repudiate a marriage on behalf of someone else may be used by women to terminate their own marriage through delegation from the husband. This is a valid and not uncommon arrangement, and according to many schools, is irreversible. Once a woman is delegated the right to dissolve the marriage on her husband's behalf, she can exercise that right at any time. Besides the waiting period, revocability of repudiation and the irrevocability of a final dissolution, classical jurists have also designed the law in such a way as to make repudiation potentially financially onerous for the husband. Upon repudiation, the husband must pay all the delayed dower immediately, will continue to provide child support, and in some cases, maintenance or spousal support for up to 2 years. Other ways in which a Muslim marriage contract can end include a wife-initiated proceeding, in which she requests a dissolution of the marriage in exchange for releasing the man of his obligation to pay the delayed dower and other possible monetary concessions. This is considered a negotiated type of dissolution in the classical doctrine. Under Canadian law, divorce cannot be dealt with by way of a domestic contract or a private agreement, nor can it be arbitrated. In other words, if I'm married and I'm able to sort out all of the issues in dispute with my spouse, so the children, the money, the property, by way of a separation agreement, if I want a divorce, I still have to go through a court process. I can't just write in my separation agreement and now we're divorced. A couple who has been married under Canadian law can be legally divorced only through the process outlined in the Federal Divorce Act. Until this happens, the marriage is not over and the couple is still considered married under Canadian law. That could have implications for tax, income tax, for instance. If I've separated from my spouse, but I haven't gone through the process of a divorce, I can't put down on my tax form that we're divorced. I can put down that we're separated, but it may have consequences for how our income tax is considered by the government. People do not have to be Canadian citizens, and their marriage does not have to have taken place in Canada for them to get divorced in this country. In Ontario, if somebody wants to start a divorce, that person has to have lived in Ontario for the 12 months preceding the divorce application. Similar residency requirements apply in other provinces and territories. This doesn't mean they both have to live in Ontario. I'm just talking about where the person who wants to start the divorce is living in Ontario. They'll follow the procedures that Ontario sets out, and among those procedures is a requirement that that person have lived here for 12 months. If both people live outside Canada in a country that does not recognize Canadian marriage, they may be able to obtain a divorce under a law called the Civil Marriage Act. Before anybody can remarry under Canadian law, they must be legally divorced. I can't marry a second spouse while my divorce from my first spouse is still underway. Both the husband and wife have the right to initiate a divorce, whether or not the other party approves. It's not something that is the right only of the husband, and it's not a case that either person has to agree with the other person choosing to pursue a divorce. Now, of course, the process will happen much more smoothly and much more quickly where the two people agree this marriage is over, we're going to get a divorce, especially if nobody's blaming the other one for what's happened to cause the end of the marriage. But even if one person is adamant to ending the marriage, perhaps for religious reasons, or perhaps because they still love their spouse and hope things will get better, that other spouse can still continue to apply for a divorce. There's for lawyers who handle divorce cases. According to the Divorce Act, a lawyer must discuss the possibility of reconciliation with their clients and inform them about services that might help them to reconcile. And now I'm going to quote from the law, unless the circumstances of the case are of such a nature that it would clearly not be appropriate. So if somebody comes into a lawyer's office, they've been separated from their spouse for a few months, they'd like a divorce, the lawyer has an obligation to say, have you considered reconciliation? Have you tried marriage counseling? Have you thought about this? Have you thought about that? On the other hand, if somebody comes into the lawyer's office, they've been separated for 10 years, they haven't seen their spouse at all in that period of time, it's less likely that the lawyer would feel an obligation to have that conversation. The same should be true if the lawyer is well informed and sensitive. If, let's say, a woman comes into the lawyer's office, talks about a relationship of significant abuse, perhaps there have been criminal charges, criminal convictions, and says, I want a divorce. Hopefully that lawyer is going to realize this is one of those situations where, as the law says, the circumstances of the case are of such a nature that it would clearly not be appropriate. According to case law, as I've said with these two examples, reconciliation need not be discussed in situations of an extremely lengthy separation, but also where there's a well-established subsequent relationship. So let's say I've separated from my husband, we've just not bothered to get a divorce, and I've now been in a new relationship for a number of years. That is going to be considered a well-established subsequent relationship, and the lawyer isn't under an obligation to discuss reconciliation with me. If there are children from that subsequent relationship, the lawyer does not have to talk about reconciliation. And as from my example, where there has been mental or physical cruelty. Lawyers are also required to discuss with clients the advisability of negotiating matters that might be subject to a support or custody order. In other words, the lawyer should be saying to the client, can you and your former partner talk through any of this yourselves? The divorce has to come from the court. That there's no question about that. But how much easier that would be if the divorce application went ahead and the applicant, the person starting the divorce case, were able to say, through negotiation, my spouse and I have agreed. This is the arrangement for the children. This is how much child support will be paid. This is how we're going to divide up our property. So lawyers are required to talk to their clients about that. That means that a divorce case under Canadian civil law can move ahead in sort of two different ways. One is where the people have worked out all of the side issues, which are called corollary issues. They've worked out the custody, the child support, spousal support, and division of property. And now they're going to court just to get a divorce. Everything else has already been resolved. Or if they haven't been able to do that, they start their court case for a divorce. They're looking for a divorce, but they're also looking for the court to make a decision about custody, child support, spousal support, and the division of property. Lawyers are required to provide a statement in which they certify that they have had these discussions with their clients as part of the divorce application. The court, too, is meant to satisfy itself that reconciliation is not possible. If at any stage in the divorce proceeding, the court believes there's a possibility of reconciliation, it shall adjourn the proceeding and give the spouses an opportunity to reconcile. So this is in the law. I can't say that I have ever seen a situation where this has happened. I have trouble thinking of what a situation like that would be without starting to laugh to myself. I have never been in a courtroom where partway through a divorce proceeding, the two people look at each other and say, oh, I think I still love you, let's give it another try. But I suppose it could happen. And in that case, the court can adjourn the matter and let the two people have a chance to reconcile and see if it's going to work. A divorce will not be granted unless the court is satisfied that reasonable child support arrangements have been made. If the two people have signed a separation agreement and the arrangements for child support seem to be reasonable, even if they're not exactly what the child support guidelines say, then fine, the divorce will go ahead. But if the court is concerned that the arrangements for child support are not appropriate, meaning that the parent who's paying support is not paying enough, the court can stop the divorce until it is satisfied that things are going to be okay financially for the child or for the children. The court can also withhold a divorce where an applicant is involved in what's called subverting the administration of justice through suppressing or fabricating evidence. As I'm going to talk about in a few minutes, for example, one ground for divorce is adultery. So if I sign an affidavit saying that my spouse has been having an affair and I've just found out and now I want a divorce, and it turns out I was lying, that there was no such affair, that's called subverting the administration of justice. And if the court finds out about that, it can stop the divorce from going ahead. I can get in other trouble too. Under Muslim law, besides unilateral or delegated repudiation and negotiated dissolution, traditional law also recognizes the woman's right to request a judicial termination of the contract, which is also referred to as a separation. Unlike the man's right to end the marriage by repudiation, and as we talked about earlier, he doesn't have to give any reason for doing that, a request for judicial separation is only going to be granted if the woman can provide sufficient grounds to have the marriage dissolved. This would typically be achieved by the woman showing the husband has failed to fulfill his basic marital obligations. Perhaps he hasn't provided financially for his wife and children in particular. Judicial separation can also be demanded by the wife if her husband has been missing for 6 months or more, or if he has not made himself sexually available to her for 4 months. Besides disappearance or fundamental failure to fulfill marital obligations, most schools do not allow judicial separation for a wide variety of reasons. This may be because traditional judges in Islam see themselves primarily as mediators who attempt to reconcile differences rather than formal enforcers of the law. The Maliki school, however, recognizes the wife's right to file for separation for harm, such as in the case of domestic violence. Another ground for judicial separation for the Maliki is discord or deep and irreversible disharmony between the married couple. And that's not unlike what the Canadian law says about marriage breakdown, which I'm going to talk about in just a minute. It must be noted, however, that most traditional mediators will attempt to intervene to reconcile the marriage, possibly through the intervention of elders. By contrast, many modern Muslim states have incorporated mechanisms for judicial dissolution of marriage that take into account different forms of abuse as well as irreparable disharmony. Under Canadian law, the Divorce Act has one ground for divorce, marriage. So this is a lot like what we hear called no-fault divorce. That's an American term. It's not really a legal term in Canada. But here, there's only one reason for divorce, and that's marriage breakdown. And it can happen a couple of ways. A marriage breaks down when the couple has been living separate and apart for at least 1 year, where either spouse has committed adultery, or one spouse has treated the other with such physical or mental cruelty that it's no longer possible for them to live as husband and wife. It's important to understand what living separate and apart for at least 1 year means. For this ground to be valid, the two people must have been living separate and apart for 1 year immediately prior to the divorce proceedings, and should still be doing so when the proceedings end. The separation must be physical, but a couple can be considered to be physically separated even if they continue to live in the same house. And this is really important because often the family's in a situation where neither spouse can afford to move out of the apartment or the matrimonial home until there is a divorce and some of the property, the value of property gets shared and there's some money to allow them to establish a second residence. So you can be living separate and apart even if you're living in the same house. There has to be a recognition that the marriage is over, even if that only comes from one of the spouses. So my spouse and I are living in the same house. I say, it's over. I'm going to move into the guest room. I'm going to stay in the house till we figure out who's taking what. But July 1st, that is the starting point for when we're going to start counting to this 1 year. It doesn't matter whether my spouse is happy about that or whether my spouse agrees with that. Once I've initiated a separation, the counting time has begun. The end of sexual intercourse is not a conclusive factor in determining whether the couple is living separate and apart, but it is one of the factors that the court would consider. Court would also consider, are the two spouses continuing to communicate? So I've moved into the spare bedroom, but are we still chatting away as though we were still in a relationship? Are we socializing together? Are we going to my father's birthday party? Are we going out to dinner with friends? Are we going to the movies together? Do other people still view us as a couple? Have we separated our financial obligations and responsibilities? Have we separated household tasks? Am I still cooking dinner for both of us? Is my spouse still doing my laundry along with his? And how are we sharing responsibility for the children? Are we spending our time with the kids separately, even if we're all still living in the same house? So you can see that while it's possible to live separate and apart under the same roof, there are a number of factors that must be present, some of which might be difficult to maintain for a year. During this 1 year of living separate and apart, couples undergoing an attempt to reconcile can resume living together for up to 90 days. And that does not interrupt the calculation of the 1 year time limit. So let's use this example. Tomorrow morning, I decide my marriage has come to an end. I tell my partner, either I stay in the house or I go and live somewhere else. That doesn't really matter. In October, we've had some conversations. We think maybe we should give it another try. We get back together again. So either if I'm living somewhere else, I move back into the family home, or if I'm living here, we begin living as a couple again. And we do that for less than 90 days and then realize, no, we were right the first time, this marriage is over. That number of days still counts towards the 1 year. So as long as it's less than 90 days, I will have achieved my 1 year of living separate and apart on June 30th of next year. But if we go past the 90 days, then we have to start over. So I suppose technically if you did it for 89 days, you get to count those days. If you do it for 91 days, you have to start over. Adultery, where one spouse commits adultery, and it can be either spouse. It can be the husband who has committed adultery or the wife. The other spouse may use this with proof as a ground for divorce. The spouse who has committed the adultery cannot use it as the basis for the divorce. It's only the other spouse who can. And it has to have been adultery that has not been forgiven, which means this. If I found out 5 years ago that my spouse was having an affair and we had a conversation and the affair ended and I said, I want to stay married to you, 5 years goes by, for whatever reason, I now want to get a divorce, I can't use that adultery as the basis for the divorce because I continued with the relationship after knowing about what happened 5 years ago. The same is true about physical or mental cruelty. So all of these constitute marriage breakdown: living apart for a year, adultery, and then finally physical or mental cruelty. For a divorce to succeed on this ground, both cruelty and its intolerability must be established. If a spouse was mentally or physically abusive to the other spouse before they married and continued that abuse after the marriage, it would be difficult to use this ground because of the fact that the person still chose to get married. So they would have to find a way to convince the court that the cruelty was intolerable even though they still married the person. So if the ground is adultery or cruelty, there's no requirement that the parties live separate and apart for a year. Upon ordinary repudiation under Muslim law, the former husband must continue to provide for his wife throughout the waiting period. Once the dissolution is final, the man must immediately pay all delayed dower, which can amount to a significant sum. He must continue to provide child support and may also be required to pay spousal support for a limited period. As we've talked about in an earlier webinar, since there's no concept of family property in Islam, property belonging to the wife remains hers, and property belonging to the husband remains his. Division of property and other payments between the former spouses are an important part of divorce. And I encourage you to check out the webinar and brochure on family property and spousal support for more detailed information about these topics. Under Canadian law, the value of property acquired over the course of the marriage, as well as the full value of the matrimonial home, even if it was bought before the marriage, is to be shared equally between the spouses upon marriage breakdown, regardless of whose name it is, regardless of who paid for it. This we also discussed in greater in the webinar on family property and spousal support. When a court is determining the amount of spousal support, it considers factors such as the length of the marriage, the functions performed within the family unit by both partners. For example, did one partner stay home in order to raise the children, thus having a negative impact on their income? Were there any agreements that the two partners entered into about responsibilities or spousal support? Current and likely future assets and means of the parties? The financially dependent partner's capacity to contribute to their own support. So have I been out of the workforce just for a couple of years and am I still young? Or have I been out of the workforce for 40 years and I'm nearing the end of a sort of typical work period in somebody's life? How old are the parties and what is their physical and mental health? Again, we discussed this in greater detail in an earlier webinar, and if you weren't able to participate in that webinar, I encourage you to have a look at it on the CCMW website because we talk about both property and spousal support in much greater detail there. Parenting arrangements for children, as well as financial support for them, must also be worked out between the parties. As I said earlier, either as part of the divorce proceedings or separately through a separation agreement process. Many people choose to use provincial or territorial laws to resolve all of these issues: property division, child and spousal support, and parenting arrangements, and then apply for a divorce simply to formally terminate the marriage. If a restraining order is needed, that must be dealt with through provincial or territorial law. In Ontario, that's the Family Law Act. There are no provisions in the Divorce Act about restraining orders. Once the people are divorced, they're free to remarry, but there is a waiting period, generally 31 days, from the time the final order is issued by the court. As with all matters of Muslim family law, it's important for people to carefully consider which jurisdictions will recognize their marriage and what laws apply to them. If a marriage is performed according to the laws of a modern Muslim majority state, it must be ended according to the laws of the same state. Informal arrangements through religious figures, either in performing or dissolving a marriage, may not be recognized under state laws if the proper process is not followed. Divorces granted outside Canada are recognized by Canadian courts. However, if a couple has been married under Canadian law and later divorces according to religious law, the divorce will not be valid and they would still be viewed as married under the civil law of Canada, which would mean they could not enter into a subsequent civil marriage. They would have to get a divorce under Canadian civil law. And that brings my comments to a close. Sabrine, over to you for questions, or Omar, if you want to add anything to what I've said, jump right in.
Omar, did you want to add anything before I start with the questionnaires or the questions?
I don't want to add anything to what Pam said. No, looking forward to the questions.
Okay, great. So let's get into it. Pamela, thank you so much for facilitating this webinar. So our first question is, so a Muslim woman still needs her husband to agree to a divorce within Islamic law, but the husband doesn't need the wife's permission, if I gather rightly by what you have said.
I'm going to leave that to Omar.
So I'll try to answer briefly because it looks like there's a lot of questions. We have to distinguish between talaq and other forms of separation. So for talaq, it's either done by the husband or delegated to the wife. Other types of separation can be done either through the courts, in which case the court can force the husband to end the marriage. So even if the husband doesn't agree and there are grounds for separation, the court can order the termination of the marriage. The case in which the husband needs to agree in some sense is the khula case, because this is considered a negotiated process in the classical tradition, even though in some modern jurisdictions it became sort of reformulated as a judicial process as well. So I guess the answer is it will depend on the concept. It's not one process in the classical tradition that exactly fits the idea of divorce. There are different paths, and yeah, it will depend on each path.
Omar, you're starting to sound like a lawyer. That's what we always say. It depends.
Yes, unfortunately, that's usually the answer.
Thank you very much, Omar. So the second question is, if a couple gets married but registers with a delay, will the marriage be considered as legal as of the time of marriage or at the time of registration?
I'm assuming that's a question about a Muslim marriage? Marriage under Muslim law?
It doesn't stipulate in the question.
But because I don't think as I understand the question, I don't think that can happen under Canadian marriage law. So I don't understand the question. Maybe Omar does.
In Muslim law, there's no such thing as registration. The requirement is to exchange consents in a public setting and for everybody to know, so that would be enough. So I don't think that would be applicable. I mean, I'm perhaps, so the question is if there's a delay between marriage and registration. I suppose that could possibly happen in a modern day Muslim country. So, but again, the question would be, it, unfortunately, the answer is it depends. If you're asking from the perspective of is it religiously valid? Yes, it's religiously valid from the moment the consent is exchanged, the conditions are fulfilled, and the marriage is made public. Is it recognized by the state? No, it's going to be recognized by the state from the moment it's registered with the state.
Yeah.
How it works in Canada, I don't know.
No, I would say the same is true. So if let's say two people got married and whoever the officiant at the marriage was, whether that was a religious leader or a justice of the peace or a ship captain, because I think they're allowed to marry people, if for some reason they didn't send in the documentation, well, it's a good question, because the documentation will state on it that the date of marriage was, let's say, June 30th. If it's until November 1st, and in the meantime, the two people split up, were they married for the purposes of getting a divorce, of needing a divorce? Probably they are, because when that document surfaces, it's going to show that the date of marriage was June 30th, plus there will have been witnesses at that marriage. So it's not generally the people themselves who submit those documents, it's the person who officiates at the marriage, whether that's a religious leader or there are several categories of people who are allowed to officiate at marriages: religious leaders, justices of the peace, a number of other categories of people. So there is a really vague answer from both of us, but I think it's the best that we can do.
Okay, thank you, Pamela and Omar. The next question is, what are the property rights of a cohabiting partner who has entered into a Nica or a Muslim contract, but not legally registered under Canadian law?
As we talked about last week, and I'll give some answers. Encourage you to look at last week's webinar, which is about domestic contracts. If the contract meets the requirements of a legal domestic contract in Canada, which means it has to be in writing, the two people have to have signed it, their signatures have to have been witnessed, then that is a legally binding document. Whether the people are married or not married, it can be seen as a form of a cohabitation agreement, or if they marry, a marriage contract.
Thank you. From the last question, someone wrote in the chat box that the Canadian Register will use the day of the marriage, the day of the couple bringing their documents in. I don't know if that further clarifies or not, but thank you, Pamela. The next question is, I guess this is not correct that only the husband has a right of divorce in Muslim law. This is not correct. This is just an interpretation or misinterpretation of Islamic law.
So if I may jump in here, because I saw with a lot of interest discussion in the chat box, kind of back and forth, and hopefully I can address it with one answer, if that's okay. So Pamela can get to all the other practical concerns. When we talk about, I mean, there is a kind of this applies to all webinars and all publications in this context, is that when we're talking about Muslim law, we're offering a descriptive view of what the schools did historically. We are not, and correct me if I'm wrong, the organizers of the webinar, we are not taking positions as to, prescriptively what we think religiously should be best. Our goal is to inform, and what Muslim law was in the classical context and the way it continues to inform religious opinions, whether by individual jurists or by modern states, is that it was the work of human jurists. So it's kind of a platitude almost, but it's all interpretation. Nobody is saying that this is the one true way of divorcing in Islam, or this is the obviously people have different positions on those things, and there are plenty of reformist positions on how the classical tradition needs to be radically reformed and so on. But what we are doing is that we are informing of where these positions come from. Obviously, we can talk about history and how these made sense in their historical context, but this will take a very long time. But who has the right of divorce? I think Pamela covered this, and I talked about it in my answer in the first question. There are different paths to getting a separation in classical Muslim law that were reformulated and introduced into the laws of modern Muslim states in different ways. And the same goes, I think, for the rest of the discussion. The discussion, I think, was about not giving a reason. Again, this is a descriptive view of the dominant schools of law in the classical tradition. This is not an endorsement of that, and there were historical reasons for this position, as Pamela explained fully in her talk, that there were financial burdens on the husband. There were social reasons to make the husband hesitate. So these are all kind of subtle issues that we can get into, but I think the point about interpretation is the kind of the general answer to all of these questions.
Thank you very much, Omar. And I'm going to go to the next question. So question 5 is, if the husband divorces from abroad, but the matter doesn't go to court right away, will the court accept the date of divorce when it was sent from abroad?
If that's a Canadian divorce, I can't answer that. There's just too many other components to what would go into that decision. So I'm sorry, without a whole lot more detail, I couldn't responsibly give an answer to that.
So I think this was a point of clarification, but one person wrote, the wife doesn't have to stay in the house after the divorce, though. She cannot marry until the 3 months are over, but I believe she does not need to be in the house. Is that accurate?
I think that's correct. I think it's usually my understanding is that this is mentioned as a right, not as an obligation, and the waiting period is basically the period in which the couple can reconcile if they resume marital cohabitation. I'm not aware of any opinion that says that she is obligated to remain in the household during that period. I can double check on that if you want me to.
Okay, thank you, Omar. I'm going to highlight that question. Thanks for double checking. So the next question is, why under Islamic law the husband doesn't need to provide a reason for divorcing? Why should one then get married in the Quran, or is it just an interpretation?
Yeah, I think I tried to cover all of this discussion through my earlier kind of general answer. So it's the same answer I gave earlier.
Okay, thank you. So the next question is, if the husband is the sole provider during the marriage, does that mean everything obtained during the marriage is his after the divorce, and her only right is her meher and what she brought into the marriage?
So if this is, I assume this is a question about classical Muslim law. So yes, the separation of property would apply. The wife would keep her mahr, anything that was given to her as a gift, anything that was her property before marriage, anything that she acquired as her property during marriage, and the husband would keep what was his, basically. That's of course separate from the question of child support and so on.
Okay. And then Pamela, did you want to add anything to this question or?
Well, sure, I can. I suspect the question is more intended to be in the context of a Muslim divorce or end of the marriage. Under Canadian law, if the people are married, everything that they acquire during the years of marriage is equally theirs, regardless of who's paid for it. So even if the husband is the sole income earner, and so everything in the house, furniture, jewelry, art, whatever, has been paid for by him, the value of that property has to be shared equally. And as we talked about in the webinar on domestic contracts and division of property, the woman still has the right to the mahar. It doesn't count as part of her property division. So let's say she's to get $20,000 as full payment of the mahar, and on top of that, there's $100,000 worth of property. She would get the 20,000 plus 50,000, half of the net family property.
Thank you, Pamela. So the next question is, what is the recourse for a woman who lives separately and persistently asks for a divorce, but the husband refuses to give one?
If that is a question about Canadian law, and I'm not sure whether it is, either person, so in this case the woman, can simply get a lawyer and go to court and apply for a divorce. It doesn't matter whether the husband is consenting or not. They've separated, they've had more than a year of separation, and so she's able to apply to the court for a divorce. He can oppose it, but they've had more than a year of separation, and so he wouldn't really have much of a basis for objecting to the divorce, even if he doesn't want to give it. So under Canadian law, it's not that the husband gives a divorce to the wife or vice versa. A civil divorce is something that's given by the court or given by the state, if you want to think of it that way. And I want to just add something to that more generally about this conversation, just because I saw a comment that Alia posted a few minutes ago. People can enter into any kinds of quote unquote marriages that they wish to. They can be married by an imam, by a pastor, by their next door neighbor. They can make any promises to one another that they wish. And if they consider themselves to be married and that they're in a marital relationship, that's fine. That's their business. It's nobody else's business. If that relationship comes to an end, unless it is a marriage that also meets the civil law requirements in Canada, those people cannot get a divorce because in the eyes of Canadian law, they're not married. So there's nothing that says a person can't live their whole life in Canada under their own set of spiritual or religious rules, as long as they're not against the law of Canada, have a relationship and then leave that relationship. But they cannot then turn to the Canadian courts and say, I want this or I want that, because if they weren't married according to the legal code of Canada, they can't get divorced under that system of law either.
Thank you. The next question is, if a woman was married for 20 years and was a housewife and then gets divorced, does the husband pay spousal support in Islam? And if so, for how long?
I'm sorry, could you please repeat the question, Sabri?
Yes, of course. So if a woman was married for 20 years and was a housewife and then gets divorced, does the husband pay spousal support in Islam? And if so, for how long?
As with most things, there's disagreement on this question. The general rule is that spousal support stops in the classical tradition. Spousal support, assuming there's no children, stops as soon as the wife moves out of. So when the idda period ends and the wife moves out of the marital home, there are some schools that provide that the wife is entitled to support, especially if there are children. She'll be entitled to support in addition to the child support. Some say for a year, some say for several years. So there are different opinions, even though the basic assumption is that spousal support is only due for as long as the couple are living together. This differs, of course, in modern Muslim states. They try to give more elaborate rights to women, even though the basic assumption under Islamic law remains dominant.
Thank you, Omar. So the next question is fairly long. I am a Canadian but was living in Egypt for the last few years. I got married in Egypt under Egyptian law, which is based on Sharia. I am now in Canada but never registered my marriage here. I am now looking to get a divorce unilaterally, and wondering if it is at all possible to do it from here in the way that the Canadian government would recognize, so that I would be able to get it notarized and stamped by Foreign Affairs in order to then have my divorce recognized in Egypt. I had been told that if it is stamped by the Department or Ministry of Foreign Affairs here, it would then be recognized by the Egyptian Foreign Ministry and thus Egyptian law. Any information on some kind of process I can go through here in order to do this would be incredibly appreciated. And if this cannot be answered here, I would really appreciate advice on what I can do about this. And there are no children and no property or assets to be divided. And I would not be looking to receive any financial support from my husband.
I'll make a couple of comments, but I want to be incredibly clear here. This is not legal advice, okay? I'm making a couple of comments on your question, but it is not legal advice to you. You really need to talk to a lawyer about this. You can certainly apply for a civil divorce in Canada. It doesn't matter that your marriage wasn't registered here. If your marriage was legal in the country where it took place, then you're married. And you apply for a divorce here, you'll certainly have to show proof that you were married. So hopefully you have a marriage certificate or some kind of document indicating that you were married in Egypt. Then you have a Canadian divorce that's, of course, recognized everywhere in Canada. I don't know then about what the impact of that divorce would be in Egypt. I can't speak to that because I really only know about laws and how they operate within Canada, but you can certainly apply for and would presumably receive a divorce under Canadian law on the basis of a marriage that took place in another country.
Thank you, Pam. So the next question is, if the divorce is finalized in a foreign country and the wife lives in Ontario and the husband filed for divorce in another country where he resides, the wife is living in Ontario for 6 months only, can she have the divorce in Ontario? In other terms, is the foreign divorce will be recognized in Ontario?
Well, I'm confused by what that question means, actually. So for what purpose does she need the divorce to be recognized in Canada? Is she going to go to a court of law in Canada and try to get a division of property that exists in Canada? That can be complicated if she's already seen as being divorced elsewhere. So that's a question that would require a lot more detail, which I don't think is appropriate to share in this setting before I could give even a general answer to it.
Thank you, Pamela. So the next question is, my Indian Nica marriage was granted by the proper Canadian divorce through the court. Do I still need to pursue the traditional Islamic khula divorce from an imam before remarriage?
That's certainly not a question for me.
It's So the marriage was conducted abroad and then divorce obtained in Canada. Is that
That's what
the
it
case?
sounds like.
I mean, again, this would be a matter of a moral preference, so to speak. But it seems to me if the divorce was fully obtained in a Canadian court, then the couple is separated. The separation. I'm not I don't kind of give opinions in a capacity as a religious scholar of any in that capacity, but it seems to me that there's plenty of intent to terminate the marriage here. And so certainly from a legal standpoint, they could remarry. From a religious standpoint, sort of in terms of feeling that one is fulfilling their moral religious duties, it might be worthwhile to check with a local imam on something like that. But as far as the divorce being valid and being allowed to remarry, I think it's clear that they would be.
Okay, thank you, Omar. So the next question is, so the 3 divorces can be made at different times in one's entire life, so that they have enough time to reflect and continue, or of course, done at once 3 times. And I'm reading verbatim.
I'm sorry, I was trying to answer something in the chat box. So that's a question about the triple talaq, is that right?
It sounds like it.
Yeah.
So the triple talaq is it's some of the classical schools allow it. They allow that if so the standard procedure is that you would sort of declare talaq, and you would go through the waiting period. If you are reconciled, then you are reconciled and the marriage resumes. You can go through this 3 times. After the 3rd time, that's it. You cannot reconcile anymore. Some view that if a husband said declare talaq 3 times, then that's it. That's final. Reconciliation cannot take place. It's disputed, and there are limitations on that in modern laws.
Thank you very much, Omar. The next question is, if a woman commits adultery, does it affect the spousal support?
No, that's the very short answer to that question. A slightly more nuanced answer would be this. The court will look at a number of factors in deciding whether support should be paid, but those are really factors that are related to the ability of the spouse who wants the spousal support to become financially self-sufficient. If I've been at home for 15 years raising our children, and I'm now, I don't know, let's say I'm 50, and my husband and I are divorcing, it's going to take me quite some time to be able to get back into the workforce, to be earning money at the level that I can support myself with. And so it doesn't really matter whether or not I had an affair. My husband has an obligation to provide me with a certain level of support during that period of time. Having said that, I'm sure that many a husband would try to raise that as a reason not to pay spousal support, but I don't think they would be very successful with it.
Thank you, Pamela. The next question is, how does the law determine extreme in mental cruelty?
Well, that's a great question. And I'm going to give the classic lawyer answer, which is it depends. So having 1 or 2 fights is not going to constitute extreme cruelty. The person, it's the wife, because that's the way it most often happens, is going to have to show that there's been a pattern of behavior, that it's gone on over a period of time, that it's got worse. That's always helpful. Has it been escalating? So maybe at first it was the odd fight, but then it turned into the husband controlling all the finances so that the woman didn't have any access to money. Name calling of a kind that's really derogatory and hurtful, maybe in front of the children, maybe in front of other family members, other kinds of psychological abuse, possibly physical abuse. That's why it's so seldom in Canada do people use either adultery or physical or mental cruelty as the basis for a divorce. It's tricky to prove. It takes a lot of work to put that evidence together. Because you can get a divorce after simply living separate and apart for a year, that's the route that the vast majority of people opt for. You know, by the time you get separated and you start to figure out who's going to live where are the kids going to live, how are we going to divide up our property, you're well into that year. So unless you're getting divorced because you've already met someone else, you've fallen in love with them, let's say you're pregnant or they're pregnant, and so you really want to get married quickly, a whole lot to be gained by pursuing either adultery or cruelty as the basis for a divorce.
Thank you, Pamela. I'm just keeping tabs on time. It's 2:12 right now. We only have a few minutes left, but we do have a lot of questions. So we are going to have to defer these questions for hopefully later, or for the FAQ that we're developing. So the next question is, I thought one did not need a justification for divorce under Canadian law. Is that true?
That's right. As long as you've lived separate and apart for 1 year, that's all that you need to show to the court in order to apply for a divorce.
Great. So if a wife wants to work during the marriage in Islam, does she have share in the family expenses? Does she have to support herself, or are these still the responsibility of the husband?
Sorry, what was the first part of the question, Sabrina?
So if a wife wants to work during the marriage in Islam,
Right. I
yeah,
see. No, it's in the classical tradition, the financial support is exclusively the obligation of the husband. So whether or not the wife marriage works is unrelated to that. Her money is her own, and she keeps her money. If she wishes to participate, it's optional for her, but that doesn't change the basic assumption is that the husband is the provider.
thank you, Omar. This goes back to Pam, what you were saying about divorce, and I think you're gonna say it depends, but just in case, but how does the Canadian judge pass that adultery was discovered and forgiven at the time and decide that it doesn't constitute a ground for filing divorce now? And I understand that if a husband or a wife is taken back after an affair, the affair cannot be used as grounds for divorce. Is there a time limit for this, like after 1 year or after 1 month? What if the spouse accepts the cheating partner back and changes their mind after a month?
Well, the first part of the question is a bit easier to answer than the second part, but because what the person has said is correct, that only adultery that causes the cheated on, if I can use that phrase, spouse to leave the marriage can be used as the basis for divorce. I find out that my spouse has been having an affair. I say, that's it, out you go, or I go out the door, and then I immediately apply for a divorce. I can get it in less than a year if I've got evidence that adultery happened. And that evidence, you know, it's not kind of like the old movies where there's a private detective watching through a bedroom window and snapping pictures of my spouse and whoever they're having the affair with. It's typically an affidavit from the spouse who had the affair and ideally the person with whom they were having the affair. But in terms of how long, you know, do I have to leave that night? Could I wait a week? Could I wait a month? Could I wait a few months? I don't think I can wait a few months if I want to use that as the basis for my divorce. I can probably wait for a few weeks on the basis that it always takes a little while to get sorted out. And it doesn't have to be the day that the adultery happened. It's from the time that I know about the adultery. So if it happened 5 years before and I can prove to the court that I didn't know anything about it until very recently, then I can still use that as the basis for a divorce. But again, I really want to stress that except in extraordinary circumstances, it's almost never worth pursuing a divorce on the basis of adultery or cruelty, because you have to come up with evidence. The other spouse might contradict that evidence, and then you're into a long, drawn out court case that's going to cost everybody a lot of money. And before you know it, more than a year's gone by anyway. And so you might as well have just applied for a divorce on the basis that you'd lived separate and apart for a year.
Thank you so much. The time is 2:17 p.m. and the webinar has come to an end. Thank you to Pamela and to Omar for answering those questions. We will be sending you an evaluation through SurveyMonkey by email later on today. Please do fill it up because your feedback will help us improve our programming and ensure that we meet your standards and exceed them moving forward. So thank you again for joining. We do have one more webinar coming up, and it's next Tuesday time, and this one is on inheritance. So we look forward to having you all join, and thank you again.
Thank you, everyone. Excellent job.
Thank you all.
Thank you. Bye-bye.